Oyez, oyez, oyez. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Oh, good morning. Welcome to today's session of court. We have cases to hand down this morning. Justice Baker.
Civil case 21-289, Cherokee Nation Businesses, LLC, and the Arkansas Racing Commission versus Gulfside Casino Partnership from Pulaski County Circuit Court, 6th Division, reversed and dismissed. Justices Wood and Womack and Special Justice Jim Spears concur. Justice Hudson and Webb dissent. Chief Justice Kemp not participating.
CV-20-663, Arkansas Department of Human Services, Crimes Against Children's Division versus Stephen D. Mitchell from Izard County Circuit Court. Administrative Law Judge decision affirmed. Circuit Court order reversed. And Court of Appeals opinion vacated.
CV-1963, Arkansas Department of Human Services, Crimes Against Children Division versus Stephen D. Mitchell from Izard County Circuit Court. Administrative Law Judge decision affirmed. Circuit Court order reversed. Court of Appeals opinion vacated.
The clerk, please read the submissions.
There are 3 appeals being submitted to the court for decision this morning. The first of which will be our oral argument, Civil Case 20-663, Hotels.com Limited Partnership and others versus Pine Bluff Advertising and Promotion Commission and others. This is an appeal from Jefferson Circuit Court. Also, we have Criminal Case 21-118, Howard Togo Wood Jr. versus the State of Arkansas, an appeal from Scott Circuit Court, and Civil Case 21-168, Zajon Thompson versus Dexter Payne as Director of the Department of Correction, an appeal from Lincoln Circuit Court. In addition to those 3 appeals, there are 17 other various motions and petitions being submitted to the court for decision this morning. All of the court's decisions and the submissions are now available on the court's website.
Okay, thank you. The court will now take up our case for oral argument today, which is Hotels.com and others versus Pine Bluff Advertising and Promotion Commission and others, Civil 20-663. And the court will now recognize Mr. Leon Holmes on behalf of the appellants.
Thank you, Your Honor.
Yes.
This case, I want to reserve 7 minutes for rebuttal, if I may. This case was certified as a class action for declaratory relief in 2013. The issue in this appeal is whether it can now be converted into a class action for the assessment and collection of taxes. In 2013, this court permitted a class action to proceed so that the plaintiffs could seek a legal declaration and said in its holding that an agency should be permitted to seek a legal declaration as to whether a tax is applicable to a certain business or certain business transactions before actually assessing the tax against a business. Thus, this court in 2013 put the case on a path where the circuit court would rule on the declaratory judgment, which was the only relief requested at the time, which would allow an appeal from a final judgment, followed by agency action to assess and collect taxes if any were owed. And we're asking the court to put this case back on that path. More specifically, here's what we're asking. Please do not allow the courts to become tax assessment and collection agencies on the pretense that the administrative procedures provided in the statutes are inferior to a class action or are futile. Please do not allow the plaintiffs to evade DF&A's exclusive authority to assess and collect the gross receipts tax. Please do not allow a substantial new issue to be inserted in a class action years after the class was certified. And please do not allow litigants to say for years, this is not a tax collection case, and we're not seeking damages. Those are quotes from what the plaintiffs have said, only to make it a tax collection class action when it becomes in their advantage to do so. While declaratory relief is not available in the administrative context, the assessment and collection of taxes obviously is. And because the legislature has determined that taxes should be assessed and collected by agencies of the executive branch, holding that a class action is superior to the administrative process would usurp the authority of the executive branch and overrule the legislature as to the best method for assessing and collecting taxes. And the potlatch.
Mr. Holmes,
Yes.
pardon me. I want to talk initially about whether or not it's appropriate for you to be before this court today in terms of whether or not we have a final appealable order to look at in terms of jurisdiction. So my question is, does Rule 2 or any other rule provide for an interlocutory appeal of an order denying decertification of a class?
Your Honor, let me say, first of all, I think this issue was addressed and fully briefed at the motion to dismiss stage, and I will rely on those briefs because I didn't study those in detail as I have the briefs here. But I'm not going to bypass your question on that basis. Yes, there is an appealable order. And the reason why there's an appealable order is that Rule 23 says that a class certification order has to define the class and the issues. When a court subsequent to the certification order redefines the issues, that's tantamount to a new certification order. And if you don't recognize that, then you're creating a path. You're laying out a way for plaintiffs to avoid an appeal on a central certification issue. The 2013 appeal would have been totally different if this case had come up as a case seeking tax collection and assessment, as opposed to simply declaratory relief. And they explicitly denied in their briefs that they were seeking damages and that this was a tax collection case. They were seeking only declaratory relief.
Counselor, what we're talking about, my question is going to, is just piecemeal litigation. In terms of our interlocutory appeals, that jurisdiction is narrow. And what it appears you are asking us to do is to create a much wider berth for parties to throw up the white flag in the middle of litigation where the circuit court has a handle on things and redefining what we would accept as an interlocutory appeal pursuant to Rule 2. So I'm wondering if you are asking this court to really charter new territory here and even allowing this appeal to be heard today.
Your Honor, the groundwork for this and the real concern, the thing that you need to be concerned about, was laid out in the Campbell case and the Farm Bureau case, which are both cited in our briefs. In those cases—
Did either of those involve the denial of a decertification?
No, but what they did, what they said was that if the circuit court allows changes in the issues that were presented, changes from the class certification order, then this court would have multiple interlocutory appeals. And it recognized implicitly in that such an event would be an appealable order. And specifically, what we're asking is the court to hand down a ruling that will avoid multiple interlocutory appeals in the future by following Campbell and Farm Bureau and saying that after the class is certified, you cannot redefine the issues and avoid having those issues be raised on appeal in a class under Rule 29A. If you go down that path and say, because we don't have a formal order certifying a new class, then it's not appealable, then you're really creating a groundwork for the— Or
would we be allowing the creativity of lawyering to redefine what is happening in the circuit court by narrating that a class has been created?
Well, Your Honor, you have to honor what's in Rule 23. And Rule 23 says
Rule 23 seems to contemplate this interlocutory appeal process would would be something that would be an option more towards the beginning of litigation where there is certification or not of a class. And so this seems to be a unique argument that you're making sort of late in the game by redefining factually what is happening in a procedural manner below.
Your Honor, I don't think we're redefining what happened in a procedural manner. I think what happened was that the circuit court redefined the issues to be presented. And that can't
Wouldn't
be
that
allowed.
be an appealable order at the conclusion of the litigation in circuit court?
When there is a final judgment, it's always appealable. But Rule 23 and this court's Rule 29A contemplate that there could be interlocutory appeals of class certification. And what has happened here is a different class has been certified insofar as the issues are now substantially different, even though the court did not label its opinion or order class certification. It didn't call it that, but in substance, that's what it is.
Because now we're looking towards damages in circuit court.
Your Honor, you're looking at assessing and collecting taxes. And yes, the plaintiffs are calling
In the form of damages.
Well, it is damages, and more specifically, a particular kind of damages, the assessment and collection of taxes. And that's something that the courts don't do. They do not assess and collect taxes.
Would you contend that our ruling on our motion to dismiss before today in regards to your argument would be law of the case that would preclude this court from revisiting the issues contained in the motion to dismiss that we took up?
It's certainly the way I viewed it before this morning. I assumed that was decided, and I looked at the order, and it said that two justices wanted to bring up the issue with the case, and I took it from that the other justices did not want the issue brought up with the case, and the majority ruled it. So I thought that was resolved.
Are you familiar with our recent decision of Ligon versus Bloodman?
No, ma'am. I'm sorry, I'm not.
Thank you.
Mr. Holmes, but aren't damages a remedy and not a new claim?
Well, it's a new issue. The Rule 23 says that the certification order is supposed to define the claims, the issues, and the defenses. And in the Campbell case and in the Farm Bureau case, the court said that the problem was that the court had allowed new issues to be inserted after certification. So it's not just claims, it's also issues. And this issue is really different because of the fact that it's totally different if you're asking for declaratory relief, which is available only in the courts. Whereas if you're asking for assessment and collection of taxes, that's available only in the administrative process. It's something that this court itself has said courts don't do. Courts can review the assessments after it comes up, but they don't decide those issues in the first instance.
So Mr. Holmes, in our decision previous in 2019 at ARC 384, that Justice Woods wrote the majority opinion, and she indicated an order which establishes the plaintiff's right to recover but leaves for future determination the exact amount of damages is not final. And we dismissed it at that point, which was a year and a half ago. How has it changed since we issued that opinion?
Well, what's changed since then is that the circuit court has determined that the class will be allowed to seek assessment and collection of taxes on a classified basis. And that redefines the issue. It makes it appealable under Rule 29A.
Okay. All right. Thank you.
I want to call the court's attention to the Highland School District case and the Potlatch case that are cited in the briefs. In the Highland case, the court said the Highland case was a case in which a school district filed an action in court seeking to collect damages. Chief, I can't quite read the time. I'm not up yet, am I?
No, you have another minute and a half.
Okay. In Highland, the court said the complaint cannot be entertained as it attempts to do what the law forbids, permit direct action against an allegedly delinquent taxpayer, omitting entirely the statutory necessity for assessment, levy, and collection. And in Potlatch, the court said because of the separation of powers doctrine, it's not within the province of the courts of law to make assessments. Those were property tax cases and they weren't class action cases, but those principles that they lay down apply. And those principles preclude a finding that a class action is superior to the administrative processes. You simply can't say that and reconcile that with the Highland School District case and with the Potlatch case. And with respect to the cities and counties, the exclusive authority for collecting those taxes is the Department of Finance and Administration, which has never been made a party to this case. Now that it's assessing and collecting taxes, they are an indispensable party. They're the true true tax collection authority, as this court said in Billy Dot versus Fields. The Appalese site, thank you, Your Honor. I'm going to reserve the rest of my time for rebuttal. Thank you.
Okay, at this time, the court will recognize Mr. Tom Thrash on behalf of the Appalese. Mr. Thrash. And you're still on mute.
Chief Justice, members of the court, my name is Tom Thrash. With me is Jack Williams and also Larry Jagley. Mr. Williams and I represent the cities and the counties and the A&P commissions. Mr. Jagley represents the state. We'd like to divide our time 15 and 5 if that's acceptable to the court.
Yes.
Thank you, Judge. In certifying the case as a class action, under the Arkansas Declaratory Judgment, the trial court found that the online travel company calculate, charge, and collect full tax on the retail price that they sell.
Counsel,
Mr. Thrash.
you're having some microphone issues.
Got some static.
Okay. Maybe I was brushing up against the mic there.
Possibly so.
Yeah. Anyway, the trial court, in certifying this case, found that the online travel companies, they charge and collect the full tax on the retail price of the room that they sell the room to the traveler, but they don't remit the full price. They remit the tax on the wholesale price that they pay the hotel for the room. They pocket the taxes they collect and don't remit. Our taxes become part of their profits. And then the OTC, they say that gross receipts tax and the hotel tax doesn't apply to them.
Mr. Thrash, I'm sorry to switch gears on you here, but before we jump into the substance of that, I want you to tell me why or why not OTC should be before this court today.
Well, they shouldn't be. The two motions that they have appealed, there's a motion to decertify, a motion, an order denying a motion to intervene, and the order denying the motion to decertify. Those decisions by the trial court were a preliminary decision that the damages could be determined on a class-wide basis. And this court has told us many times that you certify the case under a cause of action for liability. And if later you determine that damages are individualized, you can bifurcate and decertify the case for individual determinations of damages. When those motions came up, the motion to intervene, the OTCs objected to it. They didn't want them to intervene. And the court found in favor of the online travel companies and did not allow them to intervene. As part of that motion, he had to make the decision that they could pursue damages on a class-wide basis. And then the motion to decertify, denying that motion, he was presented with all kinds of evidence about how the class-wide damages could be proven, and he denied that motion for class certification. And he was at that point because the court had determined that we didn't have a final order. We weren't going to get a final order from the trial court until he determines damages. Once he determines damages, then it'll come back up to the court, and all the issues will be in front of the court. All the issues that are here for us now will be before the court on that final order.
Well, how would you respond to Mr. Holmes, to OTC's argument that they're trying to thread a needle through Rule 2 to be appropriate to bring us a final appealable order that we can hear today? And the creative argument that I believe I'm hearing is that although in form there was not a certification of a class by the circuit court, in substance, that is what happened below. And so in substance, this court should respond to the certification of this class that has been created by a new issue being presented. How do you respond to that argument?
Well, I think going back a little bit, damages are not a new claim. Damages are just a remedy from the that's allowed under the Declaratory Judgment Act. Under the Declaratory Judgment Act, you cannot petition for supplemental relief or damages until there's a liability decision. And as soon as there was a liability decision, the trial court wrote us a letter and said, it's now time to turn to damages. It's time for a petition for supplemental relief. And that's what we did. With regard to the question on the damage class certificate, this court set it out very, very clearly in Rosenau. In Rosenau, it was reversible error for the court, or for the trial court, to consider damages with Rule 23 requirements. You know, damages are not part of the Rule 23 certification. And you specifically said in that case, you must determine what elements of a cause of action are common questions for the purpose of certifying a class. And in Rosenau, the trial court considered damages when he was trying to determine the criteria for class certification under Rule 23. And this court, y'all told us that's reversible error. So doing what the OTCs are requesting right now to certify a damage class under Rule 23, that was reversible error under Rosenau. And you just don't do that. If there's a new cause of action, like those Campbell case and the Farm Bureau case, those were new causes of action where you got to go through those step by step and say, do those causes of action meet the Rule 23 requirements? But you don't do that for damages. Damages are just a remedy. And in our case, we couldn't even ask for damages until the court had determined the liability of the online travel companies pursuant to the Declaratory Judgment Act. So, in denying the motion to intervene and the motion to decertify, the trial court has already made a preliminary ruling that he thinks they can prove damages, or we can prove damages, on a class-wide basis. If it turns out, once we get the data from the transaction data from the online travel companies, once we get that, if the court determines that, there are individual issues, he can decertify and bifurcate those individual issues. So this is really a preliminary ruling that he's making. And what needs to happen is the court needs to, the trial court needs to complete his analysis and determination of damages, get the final order for this court to rule on, and all these issues that are now before the court on this preliminary order will be in front of the court on the final order, and the court can rule on all the issues. And I hope I've covered the damage portion. I'd like to address the notice portion. This court has construed Rule 23C as vesting a trial court with wide discretion in determining notice in a particular circumstance. It's subject only to the reasonable standard of due process. And you have told us that that reasonable standard of due process is notice reasonably calculated to apprise interested parties of the pendency of an action and afford them an opportunity to opt out or object. Rule 23C doesn't require you to notify the class members of the remedies that you have. It's just the causes of action. And when you're evaluating the reasonableness of the notice, you consider the type of class members you're sending the notice to. And in this case, the class members are sophisticated governmental entities that are staffed with lawyers. So certainly we gave them notice that we were proceeding under the Declaratory Judgment Act, which brings with it the right to seek supplemental relief if and when the court rules on the liability, but not until then. And so, and then the class members were given an opportunity to intervene, and they all intervened. But the OTCs objected because they didn't want the court to determine damages as a group. They didn't want the court to determine damages as a class. They wanted to sever these small entities, these small cities and counties who don't have the resources to fight these OTCs one-on-one. They want to separate them and have 160 trials out there, cases filed all across the country. And that's what, that's why they objected to the motion to intervene. This case, the damages can be clearly determined on a class-wide basis. The OTCs have already determined the tax rates and the tax amounts for each individual city and county. They did that in the collection of their taxes. They've already done all of the work to determine exactly what they collected and exactly what they kept from us. And that's our tax money that they collected. They collected it and kept it. And so the data that they produce, we can determine on a class-wide basis the total amount of damages and the total amount that they owe to each city, each county, each A&P. And so it's just really, it's an exercise, a simple exercise of mathematics. It's just an accounting, some accounting work. So in denying the motion to intervene, in denying the motion for decertification, the court made a preliminary determination that damages could be proven on a class-wide basis. And once he sees the transaction data, that's just going to confirm his decision, but it might cause him to say, okay, there are individual issues, but he hasn't been given that opportunity. And this court will not be given the facts to know that until he issues his final order. And once he issues his final order on all the damages, those issues, including the issues before you today, will come up, and you can make your determination at that time. So, and all the issues will be before the court at that time. That just seems a simple way to do this. This is the fourth time they've had an appeal to the Supreme Court, and this is really, they're appealing a preliminary issue, because up until the time he issues his final order, he can say, I think there's individual issues, and I think we need to bifurcate. That's what y'all have told us and told us and told us again. And then, and again, in Rosenau, y'all made it really, really clear. You don't consider damages for class certification criteria. It's a reversible error. So doing what they're asking us to do, y'all said is a reversible error. You've also told us where the amount of individual damages differ, but the methodology for calculating the damage is the same. You don't bifurcate. You don't decertify, and that's in the Pinson decision. And that's basically what we have here. And what I was talking about specifically in your order affirming class certification in this case. I can't see my time. Got it. You say if a case involves issues of liability that affect all class members, the predominance requirement of Rule 23 is satisfied, even if the circuit court must subsequently determine individual damage issues in bifurcated proceedings. And that's what our trial court is trying to do. You've sent the case back to him to determine damages so we can have a final order for y'all to decide. And he's trying to do that right now. He's trying to follow the determination if the damages can be proven as a class-wide basis, he'll do so. If it can't, they'll have to individualize it, bifurcate it, and prove it at that time. And then after he determines the damages, it'll come up to the court and y'all can determine at that point whether there were individualized issues and should have been bifurcated or whether it should be as a class. And that's my understanding of trying to follow this court's instructions on our class certification in class cases. Again, when you talk about assessments or exhaustion of administrative remedies, this court has already ruled exhaustion of administrative remedies do not apply to the cities and counties and A&Ps. Y'all made that really, really clear in your prior decisions. And once again, we know that the online travel companies are not going to participate in any administrative process or not going to pay one dime of the taxes that they've taken from us and pocketed. They're not going to pay 1 cent until the Supreme Court rules on their liability and rules on their responsibility. And you've told us you cannot do that until the trial court issues its determination on damages and gets you a final order. And that's what we're trying to do. This appeal is on a preliminary order of decertification and a preliminary order of intervention. And once he sees the transaction data, he can change his mind on both of those. He can say, oh, there are individual issues. I think y'all need to intervene. Or he can say, I'm going to decertify the case and bifurcate it for damage purposes. And that's my understanding of y'all's direction to us on class certification. If there are no other questions, I would turn it over to Mr. Jegley.
Court will recognize Mr. Jegley on behalf of the intervenor.
Thank you, Justices. Been following this case for quite a period of time since I first became aware of it in the reports. And the reason that I am here representing the state is because the natural question that comes to mind in looking at what's in the public record about that is, where's the state? Where are the interests of the state of Arkansas in the gross receipts tax being withheld and charged by these OTCs? And it's really simple. The OTCs have withheld, charged that tax at their retail rate from their customers and remitted the tax, though, on the wholesale rate, that which they paid for the hotel rooms. Now, if they weren't collecting the tax, what were they doing? Tax is a tax, and their transactions should be taxed as all other transactions in the state of Arkansas. They've collected it, they hold it, and they should remit it to the appropriate cities, counties, commissions, and the state. This case, I think, is fundamental to what I, as a state constitutional officer and prosecuting attorney, am supposed to do when a right needs to be put upon a wrong. In this case, there have been elements of almost criminal activity in collecting and holding taxes. For example, yours truly has brought charges against individuals at the request of the Department of Finance and Administration, as far over as Wynn, Arkansas, and other places, who have manipulated the rules concerning valuation of used cars, trade-in value, and the assessment of sales taxes on new cars. Got convictions, filed charges against individuals, charged them with continuing criminal enterprise because they're met the statute's requirements, charged them with violation of the state tax laws. This individual has also represented the state in contempt of the General Assembly proceedings, where someone has disregarded process and refused to appear and testify pursuant to a subpoena by a committee or the General Assembly itself. This particular case is no different. No different.
Mr. Jagley, let me ask you a question here. I know we've spent most of our time on procedural issues, but if we're going to get into the factual issues and the merits, I do have a question on that point. If the issue is that the OTCs advertised a price to the consumer and the consumer paid that price and they collected a tax on that full price, but then the OTC actually paid to the hotel for the purchase of the hotel room for that night for the rental rate and submitted the tax on that. And if we accept your premise that because of that difference, we have an overcollection or a distinction between the wholesale and the retail advertised price there on what was collected tax-wise, wouldn't the real party in interest here, wouldn't the damaged party be the taxpayer who paid too much, not the city who didn't collect as much? Because it seems to me that the difference in that retail price and that wholesale price is for the service of booking the room, not for the rental of the room. So aren't we kind of missing the taxpayer as the damaged party in all this? And if we're looking at a class certification, is the class really the various government entities? Shouldn't the class be the people that paid the tax if this was done improperly?
I disagree with that, Your Honor. I believe that if a tax is collected from an individual as a tax, then that tax should be remitted to the agency for which that tax is collected.
But should we just be looking at the fact that a tax was collected? Or if we're going to open this path and go down it, open the gate and go down this path, shouldn't we be looking to see if the appropriate tax was collected? For instance, if the OTC was a travel agent and I called my travel agent and said, can you book me a room in Little Rock? And they charged me a fee for doing that. Would the appropriate amount of tax be whatever was paid to the hotel for the calculation of the tax purpose? Don't we have a difference in how the tax is assessed or applied, because you have a tax that is done in a certain way for the rental of a hotel room, which may or may not apply to the service of the booking fee. So, I mean, for the moment, I'm not quibbling that maybe they collected the tax on the difference. I don't think that's really in dispute, but my issue is, just because they collected X and paid Y doesn't mean that the cities are entitled to X. It may mean that the taxpayers should be refunded the difference between X and Y because they collected too much tax. Don't we have to do that analysis and see really what they collected a tax on? If they advertised a room for $120, but they paid the hotel $100, the tax on the hotel rental for the night seems to me should be on that $100, and the difference is an overcharging of the consumer or the taxpayer?
Well, they charged $120 for the room. That's a retail transaction upon which the taxes are collected. And that money should be remitted to the proper agencies, including the state of Arkansas. Now, and to the point, this all needs to be taken care of in we need to have evidentiary findings. We need to get back in there, and we need to do the pick and shovel work so that we can bring you a final order that says this is X, this is Y, and this is Z, and this is the findings and conclusions that the trial court reached. That's where we are. With that, I will sit. Thank you.
Court will recognize rebuttal for the appellants.
Well, as Justice Womack pointed out, a lot of the argument goes to the merits, and a lot of the accusations about embezzlement and criminal activity and that sort of thing. It goes to the merits which are not before the court, and it's inserted into this appeal for the purpose of prejudicing the outcome of the appeal. It has no other relevance to this appeal. We're the ones who wanted to get the merits up here. We want the court to send it back in such a way that the next thing that happens is we get a final order so that we can appeal the summary judgment, because we believe we can show the court that the summary judgment in favor of the plaintiffs is wrong. And we don't want to go through the process of having to determine damages before we do that. And we don't think under this court's precedence that that's a proper thing, because it's not just a damage case, it's assessment and collection of taxes. Now, I want to say something about the Rosenau case. I think Mr. Thrash misreads it. The holding in the Rosenau case was that the court erred by engaging in an analysis of the merits. And it's always forbidden at the class certification stage to engage in an analysis of the merits. But determining whether it's appropriate under the Rule 23 factors to go into damages or collection and assessment and collection of taxes is not prohibited. This court has never said that. And in fact, there are some cases in the products liability context in which the court has said that those individualized issues of damages are ripe for consideration at that stage. And so I wanted to correct what he said there. He said we want to sever the cities and counties and have hundreds of little lawsuits around the country, around the state, where they don't have the resources to defend themselves. That's not what we want. What we want is, if the merit issue is finally decided against the OTCs, we want it to go through the administrative process as the statute says it must. We want an assessment and collection of taxes. And if he's right that that's already been calculated, that won't be very hard for any of them. All they got to do is ask for the transaction data. And it's not true to say that that they can't get the information. He seems to think that the assessment and collection of taxes is something that taxpayers participate in voluntarily. Well, most of us do. And I think that these parties will, if it gets down to the point where they owe the taxes. But the statutes provide for authority for the DFNA and by implication for the A&P commissions to compel the production of documents, to examine witnesses under subpoena, under oath. There are lots of ways in which they can enforce these, and to say that they're futile is to say that the statutes are simply bad statutes and that the court should disregard them because they're bad statutes. And that can't be the holding. On the merits and also on the issue that Justice Womack brought up, and why is the DFNA not here? I would ask the court to look at addendum page 4289. It's a memorandum from a lawyer in the DFNA to the secretary or then the director of DFNA on the question of should DFNA join this specific class action, and answering why not, and answering the question that Justice Womack asked about the collection of taxes. And I call the court's attention to that. And I would also call the court's attention to addendum 4232 to 35, which is an opinion letter from the DFNA, which says that the OTCs do not owe this tax. because they don't fall within the statute as it existed up until 2019. The legislature amended the statute in 2019 to include accommodations intermediaries. And the OTCs are accommodation intermediaries, and that amendment applies to them. And there's no dispute about that. So we're just talking about before September 30 or before October 1, 2019, when the new law went into effect. Prior to that, the DFNA always said that it applied to brick and mortar entities that furnish accommodations, and the OTCs do not furnish accommodations. Now, if anyone has any questions about anything else that Mr. Thrasher or Mr. Chegley raised, I'll be glad to take them. Thank you.
Mr. Holmes?
Yes.
I would ask, I guess, the same question. If, you know, again, I understand a lot of the argument today has been procedural, but if we are looking into the merits of this, and if we presume for a moment that their argument is correct, that you collected taxes on X but remitted taxes on Y, and that somebody, maybe other than your client, should be entitled to the difference between what you collected between X and Y, do we have the right class? Is the damaged party here the taxing entities, the cities, counties, A&P commissions, et cetera, or is it the taxpayer?
I simply can't concede the premise of the question that our clients are collecting taxes. What they're doing is collecting fees for their services in connection with the transaction. And that's set out by the lawyer from the DFNA at 4289, the page that I previously cited at the bottom of that page. It's not that is not something that the OTCs are saying. It's not a self-serving statement. It's a statement by the DFNA, which is the authority that's supposed to be collecting these taxes. And they say that they're fees, they're not taxes. And so Mr. Chegley and Mr. Thrash are simply disregarding and contradicting the statements by the DFNA, which is the sole authority for collecting gross receipts tax.
Thank you.
Okay, thank you, gentlemen. That concludes our oral argument today. The court will reconvene in 15 minutes for our case conference, and this court session will be adjourned. Thank you. Good day.